The judicial system is the invisible framework of the state, the structure upon which every person's freedom depends. While we go about our daily lives, it works quietly in the background, protecting rights, stopping abuses of power, and maintaining balance between the authority of the state and the liberty of its citizens. But how is this system built? Why must it remain independent? And how do courts influence the work of governments and parliaments, often without us noticing? Let's explore how judicial systems developed, what principles they rely on, and why they determine whether a society will be free, fair, and stable. Historical development of the judicial system. Ancient societies. The emergence of courts without separation of powers. In early civilizations, the judicial function was closely intertwined with the power of the ruler or religious leaders. The monarch was simultaneously judge and enforcer of decisions. Examples include the Code of Hammurabi, the courts of elders in ancient Israel, and magistrates in ancient Rome. The court was not independent. It was a projection of ruling authority. Mesopotamia and the ancient Near East. The Code of Hammurabi, 18th century BCE. One of the earliest surviving written collections of laws. The king was simultaneously legislator, judge, and supreme executive. The judicial system was built around royal authority. Local courts existed, but they acted in the name of the monarch. Key features. The court was not a separate branch of power, but a function of the ruler. Punishments were harsh, often corporal. The principle of an eye for an eye was an attempt to limit uncontrolled blood vengeance. Ancient Egypt. The pharaoh was regarded as a living deity and as the highest judge. On the local level, officials and priests both governed and judged. Judicial activity was closely linked to religion. Justice was understood as adherence to Ma'at, cosmic order. Ancient Israel. In the early period, justice was administered by councils of elders at the city gates. In the era described in the Book of Judges, charismatic leaders, judges, combined military, political, and judicial authority. Later, under the monarchy, royal courts were formed, but local courts were preserved. A distinctive feature was the strong connection between law and religious norms, the Torah, an early germ of the idea that even the king is subject to God's law. Ancient Greece. In the city-states, especially in Athens, a more complex structure emerged. Popular courts, the Hiliaea, large bodies of citizen jurors, the Areopagus, an aristocratic council, a court for serious crimes. An important step was citizen participation in the administration of justice. Though the court was still not clearly separated from the political system, the court was itself a form of popular governance. Ancient Rome. Initially, judicial functions were exercised by magistrates, consuls, praetors, and later praetors were singled out as officials with special authority over justice. Two systems of law arose: just civil law for Roman citizens, and just gentium, the law of nations, more universal norms. Gradually, a system took shape in which the praetor formulated the legal framework of the dispute. The case was referred to a private judge, iudex, chosen from among the citizens. A vast body of precedent and legal interpretation emerged. In the late Empire, the emperor became the supreme judge, and the law was codified, the Theodosian Code, later the Justinian Code. Summary of the ancient period. The court was not separated from political and religious power. However, written laws, permanent judges, procedural forms, and the first attempts to limit arbitrariness already appeared. The Middle Ages. Feudal and ecclesiastical courts. Courts became part of the feudal system. Knights, princes, or the church judged their own people. A dualism arose: secular and ecclesiastical courts. By the late Middle Ages, however, royal courts began to centralize, forming a professional judicial practice. Europe after the fall of Rome. The collapse of central authority led to local feudal courts. The lord judged his vassals and peasants. The court was an element of personal dependence. At the same time, ecclesiastical jurisdiction operated. The clergy were judged in church courts, and marriage and moral cases were also often heard there. Canon law, church law. The Catholic Church created its own extensive system of courts. Canon law was formed with its own procedures, appeals, and offices. Its important contribution, the development of legal technique, concepts, and procedures, the training of jurists at universities, Bologna and others. Royal courts and centralization. In England and France, kings began to take judicial functions away from feudal lords. Royal courts were created, where decisions of local lords could be appealed. The court became an instrument for strengthening centralized power. In England, fines and court fees went into the royal treasury, which stimulated the development of royal justice. Result of the medieval stage. Several galaxies of courts coexisted: feudal, ecclesiastical, municipal, and royal. There was no concept of human rights as such, but the idea grew that there exists a law of the land which must be observed. The early modern period, 16th to 18th centuries, codification and professionalization. The idea of the professional judge emerged. Written law was consolidated in the form of codes. The principle of the rule of law spread increasingly. The court should follow legal norms, not the will of the ruler. This marked the beginning of the formation of judicial independence. The transition from feudal to centralized states. Kings and later nation-states took judicial functions away from feudal lords. Courts became state institutions rather than instruments of a feudal lord's personal power. The professional judge. The judicial function depended less and less on birth and more on education. Corps of professional judges, integrated into the state apparatus, began to appear. Written law and codification. In many countries, the systematization of law began. Local customs were written down. The first nationwide collections of laws and royal ordinances were created. Judges gradually learned to rely not on personal arbitrariness or local custom, but on national law. The role of legal scholarship. Universities, especially in continental Europe, trained legal scholars who interpreted Roman and canon law. These interpretations strongly influenced judicial practice, pushing it toward unification and rationalization. The key shift. Judicial power gradually moved away from personal status, lord, feudal ruler, bishop, and became a state function requiring knowledge and procedure. The age of revolutions and constitutions, 18th to 19th centuries, the birth of an independent judiciary. With the emergence of Montesquieu's theory of the separation of powers, the judicial branch was separated from the executive. Constitutions enshrined the independence of courts. Appellate, cassation, and constitutional courts were created. Judicial systems became three-tiered. Enlightenment ideas and Montesquieu, the doctrine of separation of powers. The legislature enacts laws. The executive governs. The judiciary resolves disputes on the basis of law. The court must be separated from the king/government in order to protect citizens from abuse of power. The American Revolution and the United States. The U.S. Constitution, 1787, created a separate branch of government, the judiciary. The Supreme Court received the power of constitutional review, Marbury v. Madison, 1803. If a law contradicts the Constitution, the court may declare it invalid. Judicial precedent became a crucial source of law. The French Revolution and the Napoleonic Codes. The Revolution destroyed estate-based and feudal courts. The Napoleonic Civil Code, Code Civil 1804, and other codes established a clear, systematic structure of law. The judge as the living voice of the law, applying the code. Formally, the court does not create law, but merely applies it. The model, a strong legislature, and the judge as a professional applier of the law. Constitutionalism in Europe. In the 19th century, many states adopted constitutions. Courts obtained a clearer status, guarantees of independence, and formal procedures for their formation. Supreme courts appeared, and in some cases specialized administrative courts. The meaning of this stage. The judicial system became a constitutionally entrenched branch of power, not merely a body within the monarch structure. Two major paths of development emerged. The Anglo-Saxon common law model. The judge actively creates law. The continental civil law model, the judge strictly relies on codes. The 20th century, human rights, constitutional courts, and international justice. The core values of this period were independence, transparency, the protection of human rights, and later digitalization. International courts and supranational oversight mechanisms appeared. The judicial system became a key element of democracy. Totalitarian regimes and lessons of abuse. In the USSR, Nazi Germany, and other totalitarian systems, courts were transformed into instruments of the state rather than protectors of citizens. Show trials, political repression, the judicial system served ideology. This became a powerful lesson for the post-war world. Without genuine judicial independence, human rights are empty declarations. Post-war constitutionalism. After World War II, the following became firmly established in Europe and worldwide: the primacy of human rights, the necessity of an independent court as their guarantor. Constitutional courts were created, for example, in Germany, Italy, Austria, and later in Eastern European countries. They specifically review laws and actions of authorities for compliance with the Constitution. They can strike down unconstitutional laws. Administrative justice. The expanding role of the state, social guarantees, economic regulation, led to a rise in citizen versus state conflicts. Hence the development of administrative courts, which hear disputes with officials, ministries, and state bodies. This strengthened the role of the court as an arbiter between the individual and the state, not only between private parties. International and supranational courts. The establishment of the International Court of Justice, 1945, international tribunals, and later the International Criminal Court marked a new level. In Europe, the European Court of Human Rights, ECHR, allows individuals to bring complaints against their own states. The judicial system stepped beyond the nation-state. Supranational control emerged. Independence and transparency as a global standard. In the second half of the 20th century and into the 21st, almost all democratic constitutions have enshrined the independence of judges, irremovability or long terms of office, a ban on interference by other branches in judicial proceedings, open court hearings and publication of decisions. The 21st century, digitalization, globalization, and new challenges. The digital court, video hearings, electronic documents, and online access to decisions. On the one hand, this increases accessibility. On the other, it raises issues of confidentiality and cybersecurity. Big data and algorithms. Experiments are being conducted with algorithmic systems that help judges assess risks, for example, the risk of reoffending. This raises questions. Is it acceptable for decisions about a person's fate to be made with reliance on opaque algorithms? How can we preserve the principle of individualized, human-centered justice? Globalization of conflicts. Transnational corporations, international treaties, and cybercrime all require cooperation among courts of different countries, unified standards of human rights, recognition and enforcement of foreign judgments. The overall logic of development. If we assemble the entire process into one line, the path looks like this. Ancient world, court equals power of ruler/priests. Middle Ages, court equals feudal plus ecclesiastical jurisdiction, weak centralization. Early modern period, court equals state function, professional judges, first codes. Age of constitutions, court equals independent branch of power, part of a system of checks and balances. 20th century, court equals guarantor of human rights, constitutional and international review. 21st century, court equals participant in a digital, global legal system facing new technological challenges. Principles of a properly designed judicial system. Independence of the courts. A judge is not subordinate to the government and is not dependent on political parties. Independence is secured through long or protected terms of office, protection from external pressure, and transparent selection procedures. Rule of law. Everyone is equal before the law. Citizens, corporations, and the state itself. The court must be guided solely by legal norms. Impartiality. A judge must have no personal interest in the case. Recusal procedures and strict ethical standards are in place to guarantee impartiality. Access to justice. The court must be understandable and accessible, and litigation costs must remain reasonable. Judicial procedures are required to be transparent. Transparency of the court's work. Hearings are generally open to the public, decisions are published, and every judgment or ruling must be properly reasoned. Professionalism and ethics. Judges undergo training, are assessed for competence, and are bound to observe a strict code of judicial ethics. System of appeals. Appeal, cassation, and constitutional review are mechanisms that allow errors to be corrected and rights to be protected. Balance between independence and accountability. Judges are independent in their decision-making, but remain accountable for violations of the law or of ethical standards. The relationship of the judiciary with the other branches of power. Judiciary left-right arrow legislative branch. The court reviews laws for their conformity with the Constitution. The Parliament defines the framework of judicial procedures and approves the budget. Balance is achieved by the fact that courts do not create laws, and the Parliament does not intervene in individual cases. Judiciary left-right arrow executive branch. Courts limit abuses committed by government officials. The government ensures the enforcement of judicial decisions. The executive branch must not influence the substance of judicial rulings. Checks and balances. The judiciary restrains both the Parliament and the government. The Parliament regulates the organizational structure of the judicial system. The executive branch physically executes judicial decisions. Models of law. Anglo-Saxon model, common law. Countries: United States, United Kingdom, Canada, Australia. Foundations. Judicial precedents play a decisive role. A judge can effectively create law through interpretation. Courts are very powerful, especially the U.S. Supreme Court. Distinctive feature: the judiciary balances the legislature and at times may even dominate it. Continental model, civil law. Countries: France, Germany, most European states. Foundations. The court acts strictly according to codified law. Judges are professional civil servants who move along a judicial career ladder. Judicial precedent has only supplementary value. Distinctive feature: a strict, structured system with far less room for judicial interpretation. Mixed model, including Israel. Countries: Israel, Japan, several Eastern European states. Foundations: a combination of precedent and codification. An active role of the Supreme Court or High Court of Justice. A flexible approach to interpreting human rights and constitutional norms. Religious legal models. Countries: Iran, Saudi Arabia, and others. Foundations: courts rely on religious texts as the primary legal source. Separation of powers is limited. Distinctive feature: the judiciary depends on the religious and political structure of society. Socialist model, historical and contemporary. Countries: USSR, historically, China, partially. Foundations: the court is subordinate to state ideology. No genuine judicial independence. Distinctive feature: the judiciary is viewed as an instrument of state policy. The judicial system is far more than a mechanism for resolving disputes. It is the foundation of freedom and the shield that protects citizens from government abuse. An independent court maintains balance between parliament and government, ensuring justice, order, and public trust. The quality of the judiciary shapes the character of the entire state.
Hello everyone. I am very excited to share my new YouTube video with you, and I need your support to continue to bring quality and enriching content. If you enjoyed my content, please help me by like the video. It helps me reach more people and spread the message. Subscribe to the channel using the subscribe button below so you don't miss any new update or video. Press the bell to receive notifications every time I upload new content. And if you would like to support me directly and help me create more content, you are welcome to join me on Patreon. Your support is significant for me and allows me to continue investing in creating quality and enjoyable content for you. Thank you so much for joining and watching. I appreciate it from the bottom of my heart. See you in the next video.